The Supreme Court agreeing to hear Donald Trump's claim that he's immune to prosecution on federal charges of attempting to overturn the 2020 election. That puts his trial on hold, serving the former president's strategy of pushing his trials past the presidential election. Chief Washington correspondent John Carl starts us off. Good morning, John.
Good morning, George. In deciding to take up the issue of presidential immunity, the Supreme Court has effectively delayed the most far-reaching criminal case against Donald Trump, raising the real possibility that the trial in that case could be pushed back to late summer or fall, or possibly until after the presidential election.
Hey guys, this is Dr. John here. So this happening right now, Donald Trump has been telling anyone who would listen that he was untouchable, that the Supreme Court had made him immune from prosecution, that the 2024 ruling in Trump versus United States had placed him above the law, beyond the reach of prosecutors, outside the normal constraints that apply to every other American who has ever held public office.
The U.S. Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay his trial for interfering in the 2020 election. The former president described the decision as a big win. Our North America editor Sarah Smith reports.
The powerful Supreme Court has the final say on what presidents can and cannot do. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties, but they do not have immunity for non-official acts. So what does this mean for the criminal cases against Donald Trump?
He sold this as his ultimate protection. The legal architecture he spent his first term building, the court he remade with conservative justices, the rulings he believed would shield him from accountability forever. And in the span of a few weeks, that entire protection strategy has been systematically dismantled by the very institution he thought was his most reliable ally. This is not hyperbole. This is not political spin. This is what happens when a legal strategy built on a fundamental misreading of what the court actually decided collides with the cold reality of what the court actually does. The immunity ruling that Trump has been waving around like a get-out-of-jail-free card has been stripped down to its actual dimensions by judges, by analysts, and most devastatingly, by the Supreme Court itself in a separate ruling that exposed the flaw at the heart of his entire defense. Let me walk you through what just happened, because the betrayal narrative is not coming from Democrats. It's not coming from the media. It's coming from the legal architecture itself. The immunity ruling that Trump has been touting for the past 2 years does three things. It establishes absolute immunity for core constitutional functions, the things that are undeniably at the heart of presidential power. Pardons, directing the Justice Department, commanding the military in constitutionally authorized ways. Those are protected. Those are beyond prosecution. Trump was right about that much. Then it establishes presumptive immunity for other official acts. Not absolute. Presumptive, meaning the prosecution can overcome that presumption by showing that going forward would not unduly interfere with executive function. That's a much narrower protection than Trump has been claiming. And then, buried in the ruling that Trump never mentions in his rallies, never posts about on Truth Social, never brings up when he's telling his supporters he's totally immune, is the third category. Unofficial conduct, private acts, campaign activities, personal financial dealings, business transactions, things that have nothing to do with being president. The ruling says there is zero immunity for unofficial conduct. None. Zero. Zilch. That's the part Trump has been hiding. That's the gap between the protection he claimed and the protection he actually has. And that gap is where all of his most serious legal exposure lives. The D.C. Circuit, in a unanimous ruling, put it in language that even the most casual observer can understand. For the purpose of this criminal case, former President Trump has become Citizen Trump. That's not a Democratic talking point. That's not a liberal judge playing politics. That's a unanimous panel of federal judges stating in the plainest possible terms what the immunity ruling actually means. When you are dealing with unofficial conduct, the shield disappears. You are just another citizen facing the consequences of your actions. Now, let's talk about the betrayal. Because the word gets thrown around a lot in politics, usually to describe allies who switch sides or supporters who lose faith. But what happened here is different. This is a betrayal of the legal strategy that Trump built his post-presidency protection around. This is the court he appointed, the justices he elevated, telling him that his most ambitious claims of power are not going to be blessed automatically. The proof came in a ruling that didn't get nearly as much attention as it deserved. On a day in late February, the Supreme Court ruled 6-3 that Trump's sweeping global tariffs were unlawful. 6-3. That's not a narrow decision. That's a decisive rejection. And the language the court used matters. They said the emergency trade law Trump was relying on did not authorize the broad, long-term tariffs he imposed. They checked his expansive view of executive power. Those words came from Reuters, but they captured what the court actually did. Think about what that means for the protection strategy. For years, the argument was that the Supreme Court, with its conservative majority, with its Trump-appointed justices, would bless any official act defense, any emergency power claim, any assertion of executive authority that the administration put forward. That was the insurance policy. That was the thing that was supposed to make prosecutors think twice, make civil plaintiffs hesitate, make congressional investigators wonder if their subpoenas would ever be enforced. And then the court said no, not on a close vote, not on a procedural technicality. 6-3, checking his expansive view of executive power. The protection strategy was built on the assumption that the court would be an automatic blessing mechanism for the most ambitious claims of authority. The tariff ruling demolished that assumption. The analysts who study these things put it in terms that should terrify anyone who was counting on the court for protection. They said Trump can no longer credibly argue that a friendly court will bless any official act defense or emergency power grab he makes. That word credibly is doing a lot of work. It means the argument is no longer plausible. It means the prediction that a prosecutor makes when deciding whether to bring charges, the calculation that a congressional committee makes when deciding whether to issue a subpoena, the assessment that a civil plaintiff makes when deciding whether to file a lawsuit. All of those calculations have shifted. Because when the predicted outcome changes from the court will bless it to the court will apply the hardest constraints to the most ambitious claims, the deterrence effect disappears. And when the deterrence effect disappears, the accountability floodgates open. Let me give you a concrete example of how this works in practice. The hush money case, the falsified business records, the catch and kill scheme. That's not an official act. That's not a core constitutional function. That's a personal financial transaction designed to influence an election. The immunity ruling gives that zero protection. Zero. The D.C. Circuit said Citizen Trump. That means the conviction that came out of that case, the 34 counts, they are not going anywhere on immunity grounds. The official act arguments that Trump's lawyers have been floating, they're dead on arrival. Because the conduct was unofficial, and unofficial conduct gets zero immunity. The January 6th case, the pressure campaign, the efforts to overturn an election, those are campaign activities. They are political. They are not official acts in any meaningful sense of the term. The immunity ruling gives those zero protection. Citizen Trump. The prosecutors know it. The judges know it. And now, after the tariff ruling, the defense lawyers know it too. Because the court just showed that it will not rubber stamp the most ambitious claims of executive power. And claiming that trying to overturn an election is an official act is about as ambitious as it gets. The classified documents case, the Bedminster audio, the obstruction and concealment. None of that is a core constitutional function. None of it is an official act that deserves presumptive immunity. It is personal conduct. It is private behavior. It is, in the language of the D.C. Circuit, the conduct of a citizen, not a president. Zero immunity. This is the betrayal that the title is pointing to. Not betrayal by political allies. Not betrayal by members of his own party. But betrayal by the legal architecture he spent years constructing. The court he built, the justices he appointed, the rulings he thought would protect him, they are not doing what he claimed they would do. They are not the automatic shield. They are not the blanket immunity. They are, in fact, drawing hard lines at the most ambitious claims of power, which is exactly where Trump needed them to be soft. And the damage is not limited to individual cases. The credibility destruction is the thing that matters most. Because every prosecutor who is looking at potential charges, every congressional committee that is considering whether to push harder, every civil plaintiff who is weighing whether to file a lawsuit, they are all making the same calculation. What is the court going to do? And the answer, after the tariff ruling, after the analysts' consensus that Trump versus United States is actually quite narrow, after the unanimous D.C. Circuit's Citizen Trump language, The answer is that the court is going to treat the most ambitious claims of executive power with the most skepticism. That changes everything. That makes it rational to bring cases that would have seemed too risky before. That makes it rational to issue subpoenas that would have been ignored before. That makes it rational to pursue accountability in ways that the protection strategy was designed to prevent. Now, let's talk about the political dimension, because it matters too. Republican strategists are looking at the same legal landscape that we're looking at. They're seeing the same rulings. They're reading the same analyst consensus. And they are panicking because they understand that legal vulnerability combined with economic weakness, combined with the Iran crisis, combined with everything else that is piling up on this administration, is a recipe for electoral disaster. And they understand that the protection strategy that was supposed to keep Trump's legal problems in the background has failed. The legal problems are now the foreground. They are the story. They are what voters are going to be thinking about when they go to the polls. The analysts who study these things have a phrase for what's happening. They call it the deterrence recalculation. It's a dry term for a seismic shift. It means that the people who have the power to hold the president accountable have recalculated the risks and decided that the risks are lower than they were before. The court is not going to automatically bless the official act defense. The immunity ruling is narrower than Trump claimed. The tariff ruling showed that the court will check the most ambitious claims of power. So the rational decision is to push harder, to bring more cases, to issue more subpoenas, to pursue accountability in ways that would have seemed too dangerous when the protection strategy was still credible. That's what the betrayal means. It means the protection is gone. The shield is down. The house of cards has collapsed. And the only question left is what happens next. Let me walk you through the specific cases where this is going to play out first, because they are already in motion. The hush money appellate proceedings. The 34-count conviction is going to be tested on immunity grounds. Trump's lawyers will argue that the conduct was official, that it was somehow related to his duties as president, that the ruling protects him. The appellate courts are going to look at that argument, and they are going to apply the framework that the Supreme Court actually established, not the one Trump has been selling. And that framework says unofficial conduct gets zero immunity. The falsified business records, the catch-and-kill scheme, the payments designed to influence an election, that's about as unofficial as it gets. The conviction is going to stand. The protection strategy fails. The Georgia RICO case. This is the one that is moving on its own timeline, independent of the federal cases. It's about the effort to overturn the election in Georgia, the pressure on state officials, the fake elector scheme. All of that is unofficial conduct. All of it gets zero immunity. And the state court system is not bound by the same federal precedents in the same way, but the logic of the immunity ruling applies. Citizen Trump, zero protection. The classified documents case. The obstruction, the concealment, the Bedminster audio. Trump's lawyers have been arguing that this was all somehow official, that the documents were presidential records, that the conduct was within his duties. The courts are going to look at that argument through the lens of the immunity ruling's actual framework, and they are going to see what everyone else sees. A former president who took classified documents that didn't belong to him, who hid them from investigators, who obstructed the government's efforts to get them back. That's not an official act. That's a crime. Zero immunity. And then there are the congressional investigations, the subpoenas that have been issued, the documents that have been requested, the testimony that has been demanded. The protection strategy assumed that the White House could simply ignore these demands, that the courts would side with the executive, that the separation of powers arguments would prevail. The tariff ruling suggests otherwise. The court checked the most ambitious claim of executive power. It will check others. And when it does, the information that has been hidden, the testimony that has been blocked, the accountability that has been delayed, all of it is going to come pouring out. The legal analyst consensus that Trump versus United States is actually quite narrow is the most important development in this entire story. Because it's not one analyst. It's not a handful of commentators. It's the consensus of the professional legal community. The people who teach at law schools, who write the treatises, who advise the prosecutors, who counsel the congressional committees. They have looked at the ruling and they have concluded that the unofficial conduct zero immunity finding is the most consequential part of the decision. That the blanket immunity Trump claims does not exist. That the protection he thought he had was never there. That consensus is what drives the deterrence recalculation. It's what makes prosecutors confident enough to pursue cases they might have avoided. It's what makes congressional committees aggressive enough to issue subpoenas they might have held back. It's what makes civil plaintiffs bold enough to file lawsuits they might have thought were too risky. The consensus has shifted and the accountability floodgates are open. Now, let's talk about the irony. Because the ruling that Trump thought was his greatest protection, the immunity decision that he has been waving around for 2 years, is actually the thing that is exposing him the most. The zero immunity for unofficial conduct finding was always there. The careful legal analysts who read the decision closely knew it from day one. But Trump chose to ignore it. He chose to sell a fantasy of blanket immunity. He chose to tell his supporters and his lawyers and the world that he was untouchable. And now that fantasy is colliding with reality in the most devastating way possible. The tariff ruling was the moment when the court itself showed that the fantasy was false. 6-3. Checking his expansive view of executive power. The justices he appointed, the majority he thought would protect him, they voted against him. They told him that the emergency power claim he was making went too far. They told him that the court is not the automatic blessing mechanism he thought it was. And that message has been received by prosecutors, by congressional committees, by civil plaintiffs, by the legal analyst community, by Republican strategists who are now trying to figure out how to run a midterm campaign with a president whose legal protection has evaporated. So where does this leave us? It leaves us with a president who is more exposed than he has ever been. The immunity ruling does not protect him from the cases that matter most. The tariff ruling shows that the court will not rubber stamp the most ambitious claims of executive power. The legal analyst consensus has shifted against him. The deterrence effect is gone. The accountability proceedings that were being held back by the fear that the court would bless any official act defense are now moving forward. The hush money conviction is going to stand. The Georgia case is going to proceed. The classified documents case is going to move. The congressional investigations are going to get more aggressive. And the Republican Party, which has been defending this president for years, is watching it all happen and wondering how they are going to survive the midterms. The protection strategy that Trump built, the legal architecture he spent his first term constructing, the court he thought would be his shield, has betrayed him. Not in the way that political betrayals happen, with allies switching sides or supporters losing faith, but in the way that legal strategies betray you when they are built on a misreading of what the law actually says. The immunity ruling was never as broad as Trump claimed. The court was never as automatic a protector as he assumed. And now, in the most visible and devastating way possible, he is learning that lesson. The house of cards has collapsed. The protection is stripped. And what remains is a former president, a current candidate, a man who spent years telling anyone who would listen that he was above the law, facing the reality that he never was.